Good afternoon and welcome to this CAP6 webinar, the legal and practical considerations for identifying and combating tenancy fraud. I'm delighted to see so many of you joining us, and there are lots of familiar names and faces here today who've attended previous tenancy fraud seminars that I've put on at our offices over the years. So as a result, most of you will already know, but for those of you who I haven't met before, I'm Helen Gascoigne. I'm an associate solicitor here at CAP6, and I am very passionate about fraud, or as I should say, counter fraud, to keep me out of trouble. There is good news today. You won't have to listen to me get terribly overexcited about subletting and the like, as I have persuaded two incredibly knowledgeable experts who also share my love of all things fraudulent to change out of their loungewear and join us today. Our own Katrina Robinson MBE, who is also an associate here at CAP6, and Barrister Andy Lane of Cornerstone. So we'll be covering both the practical aspects with Katrina and the legal angle with Andy. And of course, there'll be a Q&A at the end, so you'll have the opportunity to pick our brains. So if you do have any questions, if you could please use the Q&A box that you'll see on your toolbar, and you can submit these any time during the webinar. You'll be able to see all the questions that are put forward by other participants as well. So if there's any that you like, you have the option to like them, and what that will do is that will push them to the top of the list. So it will give us the ability to see which ones you're most interested in, so that we can have a look at those at the end. I am required to do some boring but very quick housekeeping, although this time I'm not going to be telling you where the toilet facilities or the emergency exits are, so I'm going to be relying on you to know that this time. So firstly, just to let you know, the webinar is being recorded. We'll share the link afterwards, and we would welcome you to either revisit the content or share it with your colleagues. Please feel free. If you do experience any technical issues during the afternoon session, then if you just use the chat box and raise it with our support team, they will be able to assist you and sort that out for you. And finally, we'll send you a feedback form as usual. And if you could please take the time to complete it, we'd be really, really grateful, and it helps us to improve our events. So we've got an hour's webinar today, so I shan't take up any more of the precious time, and I will pass you over to the wonderful Katrina Robinson.
Thank you very much, Helen. Hello, everybody. Many of you will know me from my time as an in-house solicitor for various housing associations, including Viridian Housing, Servite, Optivo, Shepherd's Bush Housing, and during those times I also managed tenancy fraud investigators. Some of you will also know me because I owe you money, and I'm really sorry about that. I'm getting around to it. So I'm at CAP6 now, thoroughly enjoying myself. I'm still the chair of the Tenancy Fraud Forum, which is a completely independent organisation, which I'm sure you know about. If not, we'll talk about that later. If you're wondering the reason for that screen that has just come up, like you, sometimes I find Zoom meetings and Zoom conferences difficult, and I can't always see people clearly. So in case you're wondering what I actually do look like, because Zoom distorts things, and that's a picture of me if you ever see me out and about. It's also, I think, important to set out that one of the reasons I am particularly passionate about tenancy fraud is not, you might be surprised to hear, because of the law. Obviously, I am interested in it because of that, but I had two former friends who were subletting a housing association property. They're still doing it. They've been doing it for 16 years. On the back of the profits they have made, they have purchased two properties in Brighton, which they are now lawfully subletting because they own them. I think they've made so far over £200,000 profit, and things like that just make me absolutely crazy. So what I'm going to be talking about is the practical aspects of tenancy fraud, essentially how to spot it within your organisations, how to stop it and how to end it. And when I have finished wittering on, I will be passing over to Andrew Lane, who's far more cleverer than what I is in terms of dealing with tenancy fraud. So we'll be looking broadly at lettings, right to buy and right to acquire, subletting, abandonment and succession. If I don't particularly address any of those, all of the tips and the practical tips I give you will apply to all of those areas anyway. Oh, next slide, please. I feel like Professor Chris Whitty now. So who are the investigators? It's not just you. You can't possibly do this on your own. If you have been tasked with looking at tenancy fraud within your organisation, whether you're a qualified tenancy fraud investigator or a housing officer, you still can't do it on your own. It is everybody's responsibility, and everybody can help you. What tenancy fraudsters will think is that it's the housing officer who is the person who's going to catch them out. They won't suspect your repairs men and women. They won't suspect the gas team or the surveyors. So try and get everybody involved as much as you can, that if they get the slightest hint or the slightest suspicion that there's a tenancy fraud, they're not expected themselves to start interviewing the people and doing anything further. They just need to tip you the wink when they get back to the office. So, for example, with your DLO team, I used to have meetings with the repairs men and women, you know, some ungodly hour at like 6 o'clock in the morning when my curlers were still in and my teeth were still soaking, to say to them, if you go around to a property and there's locks on the bedroom doors, just let me know. That's all you need to do. If you go around to a property and there's a couple of mattresses or beds in the living room, just let me know. That's all you need to do about it. So everyone is involved with this. And the more you raise awareness, the more referrals you will get. In terms of customer services, for example, they are the colleagues who will be speaking to tenants who phone up, who say, oh, I'm just going away for a while. Please, can you give authority to my friend who's going to be looking after the flat for me? You know, that's a real red flag. So all of the things, including residents associations, as soon as you get them engaged, the chairs of residents associations and the members, that will be fantastic for letting you know what they think is happening within a property, be that subletting or abandonment, or indeed right to buy if the person's moved out and they're then putting in an application for right to buy or right to acquire. So we'll address some of these a bit later. There's also to be said as well that I'll say in the last slide, but I'll raise it now as well, that you are allowed to tell porkies to tenants if you're investigating tenancy fraud. Some people have said to me before, well, we're not allowed to be untruthful to them. Well, you can. You can't phone up a tenant and say, oh, your rent has tripled and we need it in cash every Monday morning. Obviously, that's the wrong type of porky. But you can, to investigate what is a criminal offence, you know, to stretch things somewhat. I've been around to properties pretending to be a surveyor in a fluorescent jacket and, you know, knocking plaster and going, oh, that plaster looks like he's blown love, and pretending to measure things. And I've gone with a proper surveyor, and it's given me the opportunity to have a look around the property and take photographs. So telling porkies is fine. And it's very, very important to make sure that the work you're doing is put out there so people know, you know, you're doing great work, you want to tackle tenancy fraud, but it's no good if it's just you and your colleagues that know about it. Having tenancy fraud champions is a really good idea, because they will talk about it continually and encourage referrals. When I first started at Shepherd's Bush Housing Association, I took over a spreadsheet that had details of the tenancy fraud cases. There was 3 cases on it. By the time I left, there was 58 cases on it. And that's not because I'm some intrepid investigator, it's because I went on and on and on and on about it, to the extent that the people then thought, oh, that sounds a bit fishy, you know, we better let Katrina know. So that's why, you know, you need to get out there and know that you're the person that's passionate about it. Posters on your estates and your offices is a great idea. Not only will it encourage people to refer things to you, but it will also make the fraudsters hopefully think again. And getting local media involved is a fantastic idea. The media love a good story. So whatever your local newspaper is or your local radio station, then get involved with your local authority or with your local housing associations, do some partnership working, get things out there on the local radio, a 5-minute spot. You know, this is what ABC Housing are doing with local authority partners. They're coming at you if you're a tenancy fraudster. Really highlight the fact that people are on waiting lists for far too long. They need to have secure accommodation. So it's a great story. The press love it. I know in Devon there was the Devon Audit Committee and the Devon Tenancy Fraud Forum put signs on local bus stops. So where the buses come up and it says you have to wait 5 minutes for your next bus. A message will flash across about tenancy fraud as well, which is a really great idea. So let's look at lettings now and mutual exchange. So obviously this is where the fraud will start. When people misrepresent their situation to try and get a property in the first place. So this is where it needs to start, I would say. People will say mass to try and get a property. It's very, very important to make sure that you have proper training about document verification. There's probably many of you, including myself, if somebody showed you their passport, you wouldn't know whether or not it was fraudulent. There's little lights you can get. When you go into a shop or a bar and you're lucky enough to have a £50 note. I mean, I've not seen one of those since the 70s. And they will put it under a scanner to show if it's got the correct lighting that shows up on it, and it will show the strip. You can get those little handheld torches as well for passports and other ID cards to make sure that they haven't been fraudulently produced. But what I would suggest is get yourself some proper training. Lots of people do free training on document verification. I haven't gone into here where you can get that free training, but by all means, if you feel that it's something that your organisation wants, then drop me an email and I will put you in touch with those various people who can do that for you. Also, birth and marriage certificates, especially if they are from overseas. If you look at that website link that I have given you there, that is a link to lots of commonly produced identity cards and passports from across the world. So you know at least what they are supposed to look like in the first instance. I had a case once, it's going back a few years now, but a woman came in with a passport and she had a stamp in it saying indefinite leave to remain in America. And she was dressed really fancy, and the place we were letting to her wasn't in the most gorgeous of areas, and we just thought that's a bit weird. If you've been living in New York for years and what have you, why would you suddenly want to move into this property? And it all sounded a bit odd. And we took her passport away and we said, oh, we just want to have a closer look at your passport. And we went back down to reception after 45 minutes and the woman had legged it. It's because it was a false passport, and she obviously thought, I'm in trouble now. So everything was false. So do not accept at face value everything that's just given to you. Take colour photographs of your new tenants. If some people think it's a Data Protection Act issue to take photographs, it isn't. Sharing those photographs could possibly be, but taking the photographs is not a data protection issue. I would say no photograph, no tenancy. Do be very aware of taking photographs of existing tenants if you decide to do that, because the people you might be taking a picture of course, might not be the tenant, so you could be allowing them to stay there accidentally, is what I would say. So definitely do take photos. Succession is an enormous increase. There's an enormous increase in succession fraud at the moment. Sometimes it's the only way that people can get themselves social property. I have dealt with no end of cases where it's a one-bedroom flat and they say, Mum or Dad has passed away. I was sleeping on the sofa and it was a one-bedroom flat. Some of that might ring true with you, but succession fraud is definitely on the increase. Definitely within the Tenancy Fraud Forum, there's lots of people who have noticed that. So the tips I would give you in respect of succession is, first off, talk to the neighbours. Neighbours are marvellous for the information that they can give you. Do be a bit wary, however, that if the neighbour gets on very well with the person who's subletting or the person who's claiming to succeed, they might cover up because they might think, well, I'd rather Joe Block stayed there, then someone else moved in, or I'm not going to get on with. But neighbours are a great, a great source of information. Obviously, of course, you're going to want the proof of the relationship. If someone comes in and says, I'm the nephew, I'm the cousin, I'm the great uncle, what have you, then you need to be sure of that. And they're the ones that need to prove it. It goes far more than just saying, well, we're related, and I was living there. Of course, there's going to be some situations where you've got a couple who were married or indeed not married, but a couple, and one of them has passed away, and so there's an automatic right to succession if there hasn't been a previous succession. So I'm not saying all succession cases need to be treated with suspicion. I treat everything with suspicion. I can't help it. I was just born that way. But also do credit searches as well on the people who say that they want to succeed to the tenancy, to see if you can link them somewhere else. And very important, get a completed application form that has a clause on it where they sign to say, everything I'm saying on this form is true. I accept that if I'm telling you porkies, obviously you won't use that language, but if I'm telling you porkies, then I might lose the property in the future because I'm misrepresenting it, misrepresenting the facts. So very important. If someone has died, which they will have in a succession case, obviously, put in a Data Protection Act request to the healthcare professionals. So they might, depending on the reason why they passed away, have had home carers go in there. They might have been visited by home help, by social services. Ask those people, who was there when you went round to the property? Was anyone sleeping on the sofa? Andy will cover Data Protection Act request as well. I do have the particular form of words that you use when you rely on the Data Protection Act for information because you are investigating a potential fraudulent offence or because you want to get legal advice. I haven't put that up here, but if you want that particular form of words, by all means, email me and I will send it back to you. Again, with historic repairs, so you've got dad, he's 90 years old, he was really, really ill. His son was living there, so the son says, who's been reporting the repairs? Who's been dealing with it? Who was signed for the gas safety checks? If the son sleeping on the sofa wasn't there, then obviously that's an issue and something for you to raise your suspicions. Electoral roll, housing benefit application forms. I'll move on to social media shortly. Also, don't just rely on bank and utility bills. Again, I had another case where somebody wanted to succeed. They produced a bill from E.ON. The bill from E.ON, the bloke had taken it off the E.ON website, in the part of the website that said, when you become our customer, this is what your bill will look like. He'd taken it from there, photoshopped it and put his name and address on it. The housing officer at the time said, oh, well, I've seen the electricity bill, but we had a system where you could not agree a succession unless a tenancy fraud investigator improved it, and they picked that up. So that's that succession. These are things which should make you, if I always want to sing, this comes up. I won't be singing Elvis Suspicious Minds, but that's what's coming into my head. If you've got a tenancy fraud case, and these aspects come to the fore, then it should just basically give more fuel to your fire. I'm not saying that everyone who's in rent accounts and credit is subletting, because that would make you very busy, wouldn't it? But generally, people will keep their rent accounts in credit because they want to keep you away from the property and away from bothering them. So that's why some people will say, let's just keep the rent account in credit and they'll just leave us alone. A lot of those are, fairly obvious: brand new antisocial behaviour, failure to allow access, again with a previous suspicion, not just on its own. Otherwise, you'll probably think that all of your tenants are tenancy fraudsters. And also, as I said before, information from contractors and from your DLO people, that there's locks on bedroom doors, that type of thing. But also the tenant not knowing relevant information. They might know when the tenancy started because they could be a friend of the tenant who living there, so they've been given the relevant information, but they might not know other things, like when was your boiler last replaced, when did your rent last go up, so that sort of information. You might also get cases where people are, it's just a friend's day and I'm overseas again for a family funeral. I've dealt with some cases where tenants have had so many people die on them. I'm thinking, you don't need legal advice in respect to this. You need to go and see a good doctor because they're dropping off like flies, you know. So anything that just doesn't sound right is something to add to your tenancy fraud investigation. Of course, those of you of a certain age will just be like, no idea who that is. That's Cagney and Lacey. Those of you who are more mature, should we say, will know they are the best American cops ever. If you haven't watched it, get it on Netflix. They're fabulous. So much of the investigation you can do in the comfort of your own armchair. It would have been at your office desk, but we're still in lockdown, so you can do it from the comfort of your own armchair. You don't have to get up there and start chimneying up drain pipes and looking through letterboxes. Not that, you know, not that I'm saying you shouldn't do that, but these are some suggestions of what you can do to look into matters for you. So you can use social media, have a look on things like Facebook and LinkedIn. Don't send them requests for matters. Just view, see what they say, see where it says that they live. Screenshot everything, screenshot absolutely everything. You can do data matching with your with commercial organisations or with your local authorities if they're working with you, which is fabulous. Google is your friend. Google absolutely everything. Do signature matches with your CB12 certificates. Your local authority partners can do home office movements checks for you to see if people are still in the country. And I can't recommend enough NAFIN, the National Anti-Fraud Network, which is run by local authorities. They act as the authorised officer for requests under the Prevention of Social Housing Fraud. So if you're a housing association and you want to get things like bank statements to have a look to see if there's any rental income, join up NAFIN, really, really good idea. But go mad on social media. I've also used cases where I put in CCTV, a bit different if you're a local authority. If you're doing direct surveillance, you're going to need authority from the magistrates under the Regulation of Investigatory Powers Act. But in cases that I have found tricky to get all the evidence I need, I've put in CCTV, and I've seen the tenant unlawfully evicting their subtenants, you know, and I sit there and watch it on my phone when I'm bored with watching Midsummer Murders. I think have I got 5 minutes? How much longer do I have left, Helen? You can give me you can wave your fingers. Oh, I've got 1 minute left. Heavens, I shall rush through this. Tenancy audits. Tenancy audits, hugely important, unannounced always do them unannounced. The friends I was talking about who moved to Brighton, the landlord wrote to them and said, we think you're subletting, we're coming around to do a tenancy audit. What a surprise, they were there. So then they closed the case. So there's some views there of what you can do with tenancy audits. Make sure you try and get into the property. People will say, you need to give me 24 hours notice. You know, that might be right according to your tenancy agreement, but you can still try and get in there. Take photographs of posts in the communal hallways. Don't open the post or take it with you because that's a criminal offence, but take photographs so we can see whose names are on there for later desktop investigations. If you find subtenants there, be nice to them. Don't say you're not supposed to be there and scare the life out of them because they'll give you no further information about the subletting. And we'll move on to referrals. I think that that sort of does what it says on the tin. That will help you to get more referrals. So keep you busy anyway. Next slide, please, Mr. Whitty. So I'll leave you quickly with some top tips. Create a relevant alert on your systems. So when people are dealing with a particular tenant, there's an alert on there that says this is a suspected tenancy fraud case. Act natural until you've got all the evidence. Do not let the tenant know that you're aware of the suspicions until you've got the whole shooting match. Keep notes of everything. For example, you know, I feed my neighbour's cat, but I don't put on my Little Pony pajamas to go and do it. So you open the door, someone says, oh, I'm just a friend feeding the cat. They've just gone down the shop. No, you're not. You're in your dressing gown. So finally, the Tenancy Fraud Forum is a free organisation that brings together all social landlords to tackle tenancy fraud. It's a fabulous place to get information, to share ideas, and to join forces with other fraud investigators to get some ideas. So that's me. Sorry I had to bolt through some of it, but you know where I am. And I'm going to be quiet now.
Thank you so much, Katrina. That was excellent. There's some really, really good practical tips there. I'm sure everyone will agree. And I can certainly see from the question and answer box that there's some good questions coming in, some great feedback on some of the stuff that you've given us there. So we've got a few bits and bobs to answer. But yeah, excellent stuff. Thank you so much. We can all put our investigative hats on and squirrel off and go and catch the naughty tenants. So now I have the pleasure of passing the baton over to Mr. Andy Lane of Cornerstone, the person who actually wrote the book on on tenancy fraud. So it's my pleasure to introduce Andy, and he's going to take us through the legal side of things. So you've heard the practical side from Katrina. You're now going to hear the legal side from Andy. Thanks, Andy.
Thank you very much, Helen, and thank you, Christina, for a typically excellent presentation, which will have given you a fair idea as to what needs to be done to investigate housing fraud. If there is any background noise, it tends to be the grazing gardeners who seem to know when I start a court hearing or presentation, and so they'll start cutting the grass again. So apologies for that. I think Katrina had about 12 slides to get through. I have 21, but as you might imagine, what I'm planning to do is really use the slides for a backdrop, because as you've been told, I think in the Q&A and the chat function, you are going to get the links and so on, so you'll have the slides in any event for your use. What I'm trying to do is just to try and give some of the key legal issues on some of the areas that we've highlighted in this talk: subletting, allocation fraud, a little bit on criminal sanctions and civil damages, and obviously issues to do with evidence. There are obviously some issues we're not covering and haven't got time to cover, such as, for example, internal fraud, which may involve people letting properties when they shouldn't be letting properties to people who may or may not be innocent themselves. So to start off with subletting, it's probably the most common housing fraud matter that people come across. And it's worth mentioning a few basics. Firstly, we're initially talking about subletting of the whole of the property, whether that's a one-bedroom flat or a four-bedroom property or anything in between. And therefore, we're looking at situations where the tenant or tenants are living elsewhere. And that, of course, will give us the opportunity of perhaps discovering even more information about what's happening, because there'll be a second property involved. It's also worth remembering that if you are subletting your property, you have lost security of tenure. You can no longer be a secure tenant, you can no longer be an assured tenant, and you cannot regain security of tenure unless you are in a shared ownership arrangement where that provision doesn't apply. So the only way then you can get back in is to have a new tenancy granted, and you'd have to be fairly stupid to do that. Not the tenant, but the person offering the new tenancy, I hasten to add. As for ending these tenancies, fairly straightforward. With the wonderful periodic tenancies, it's very easy. You just serve your notice to quit. And of course, the key with notices to quit is that they end the tenancy, unlike notices seeking possession. At the expiry of the notice, the tenancy will have come to an end if you're right. And that applies to periodic tenancies. Fixed term tenancies, or for local authorities, flexible tenancies, which I hate, and I really wish everyone would go back to periodic tenancies. But with fixed term tenancies, you may well be looking at use of break clauses or use of forfeiture. And of course, if you're looking at the latter, you may have issues such as waiver and so on coming in as well. The other point about subletting is that in terms of damages claims, it's worth pointing out that the unlawful profit order, which is basically the tenant paying the landlord whatever profits they've made from their activity, is very simple, very straightforward, and very easy to get. And a good example of that, which I've put at the end of the first slide, is the Riverside and Allocation case, which is one of CAPSIC's case, latterly Katrina's case, which I dealt with recently, where we got 145,000 unlawful profit order for a woman who had been subletting her premises for 11, 12, 13 years. And we had to obviously make up a lot of the figures by way of best guesstimate, but that was accepted by the court. So those are some basic information. The next two slides, I've, in a sense, split it into four different cases, primarily in the Court of Appeal. But the cases themselves aren't that important, save as to prove a point. But really what they're looking at is to make the point that a letting, in other words, something that you shouldn't be doing of the whole at all, and you shouldn't be doing of a part without telling your landlord and getting their permission, is a letting, whether that's for a week, for a year, for 10 years, for 15 years, it doesn't really matter. The point of the matter is are you letting the property? In other words, have you given exclusive possession to somebody for a period of time, and normally at a rent? So if I go and stay at my brother's, I'm not a tenant, I'm not a subtenant, well, unless he starts charging me, I suppose. He's just allowed me to stay in his house, and therefore that's fine. If I am a friend over from another country, same kind of thing. I would just remark there are quite astonishing stories about people who have had friends over for a period of time, perhaps from other countries, yet they have been on electoral rolls for 7, 8, 9, 10 years, and therefore have obviously come over for some considerable period of time. And also, of course, it means that if you are not concerned with the period of subletting, it means that Airbnb is also covered by that, which I'll briefly mention later. Of course, even if you haven't sublet, but you have actually yourself moved out and allowed somebody else to move in, even if you're not accepting rent from them, you may be treated as having parted with possession, which is equally as unlawful and worthy of a notice to quit in a periodic tenancy case. It's therefore the case with subletting that the intention of a tenant to return is not really of any great relevance because they've moved out. It's not like an own your principal home case where somebody hasn't sublet, they've just abandoned for a period their property. It's the subletting. And as I say, that will end the tenancy and security of tenure once and for all. If you can identify the second property, in other words, the property where the tenant's moved to, the burden of proof effectively flips to the tenant. It effectively requires an explanation from the tenant as to why are you connected with the second property? Why are you on the electoral roll at this second property? Why is that property used as the address for you with your children's school? Why are you using that property when it comes to claiming credit? So they will have to explain, and the burden will move to them to explain that. But even if you don't have that problem, and even if you don't have a second property, that doesn't mean you can't seek possession. And if we go back to the Riverside case, we did have a second property, but to be honest with you, I was always of the view that it wasn't entirely clear whether that was the property where she was actually living at. But the key was we had sufficient evidence that she certainly wasn't living at the demised premises where she should have been, and that's the key. I should also say, finishing these couple of slides, is that you'll get some tenants who will attempt to say, well, I haven't sublet the whole. I deny subletting anything, but I certainly haven't sublet the whole because I still have access to the premises. I still have a room there. Now, Helen knows this better than anyone because she was involved in the wonderful case of Poplar, Harker and Begum, where they left a room locked with their belongings in or certain things in that room and allowed other people to stay in the rest of the flat. And therefore, there could have been no subletting of the whole, it was subletting of the part, and therefore, at best, was a breach of tenancy. And if we look at the next PowerPoint, we will see that issue. And you've got that there, the Poplar and Begum case. And of course, what it does mean is that you don't have an automatic right to possession, because with a notice to quit, you have an automatic right. The security of tenure has been lost. The notice to quit has brought the common law tenancy to an end, and the people there are trespassers. Subletting of part, because you haven't allowed all the rooms in the property to go to the subtenant, effectively means that you have breached your tenancy, because your tenancy will invariably say you must get our written permission if you want to sublet the part, and they won't have done so. But it does then become, for local authorities, a Ground 1 case, for housing associations, a Ground 12 case, and therefore a discretionary remedy. And the point is, in those cases, and we can see this from the next slide, is the wonderful judgment of Mr. Justice Turner. Now, don't worry too much about the design of the slides. I found the design function on my PowerPoint program, and it therefore made me all kind of excited, but it has no great meaning other than that. What you see here, and all I would really focus on, is paragraph 40, or the part of paragraph 40 of his judgment, where he said, I would stress that it's not compassionate to allow profiteering fraudsters indefinitely to continue to occupy premises and thereby exclude from such accommodation more needy and deserving families. Now, that's a paragraph worth using, not just in subletting cases, not just in subletting in part cases, but also, for example, allocation cases where somebody has lied in order to get a property. In other words, it may be a discretionary ground, but it's not like antisocial behaviour. It's not like rent arrears, where you're normally looking to the future to see if things will improve. The damage has already been done. You've jumped the queue, you've misused the tenancy, you've used up your chances, and the principle should be, as we'll see later, that public policy dictates that an outright order should be made unless there's some compelling circumstances suggesting otherwise. So subletting is fairly straightforward in that sense and legally. It does include, as I indicated earlier, or I should say could include, because the jury's still out to an extent, but it could include Airbnb, Booking.com type references. Now, in relation to those, it seems to me with modern tenancy agreements, it's sensible to include something about these type of lets in your tenancy agreement. So at the very least, it's a breach of tenancy, even if you remain in the property, if you use part of your property or all of your property for such arrangements. But as you've seen from the summary that you can see there, which actually is taken from my book, there has been authority, including from His Honour Judge Luber QC, which is fairly good, which suggests that they can be lets, because of course they can be allowing somebody in with exclusive possession for a period of time at a rent. So they could, in the right circumstances, be a letting. And therefore, in those cases, it's worth considering that part. What I'd also say, incidentally, for those of you who have long leases, or more particularly shared ownership, it's almost certainly a breach of that arrangement, because those agreements will have something about use of the property, about one family residence only, and therefore, and not to be used for commercial uses, although there has been some indication that it's not treated as a business use. But short-term lets are in principle possible sublets. If we can go to the next slide and looking at the evidence. So it's all very well saying, well, look, that's fairly straightforward with something like subletting. What do we really want to look at? Well, Katrina's already looked at some of the issues such as NAFIN and CCTV and the REPA and data protection requests. And I'm a particular fan, as we'll see in a minute, with pre-action correspondence and interviews, absolutely crucial. Detailed pre-action correspondence, very important. And also what I would we will know as Part 18 requests, which I'll come on to describe, but effectively are a part of a court procedure which requires a defendant to give further information beyond what they've set out in their defence. But before looking at that, if we can just have a look at 4 preliminary evidential matters. Firstly, you have to treat the trial that you have if you decide to take a matter to court as your one and only chance to succeed. In other words, get your evidence together. Serve your notice as quickly as possible, but get your evidence together, even if that's late in the day, because you're still investigating as you're preparing witness statements, as you're preparing disclosure. Get that evidence together. There are circumstances where you can set aside a possession order, if it's shown that somebody committed fraud during the trial, but treat it as if this is your one and only chance to succeed. Secondly, ongoing duty to disclose. So just remember that should go in the trial bundle. Thirdly, inferences, and you can see this from the Vandra case, suffice. In other words, you may not have direct evidence. The subtenant may not be prepared to come to court, but you have enough inferences. When you went round, they said that they were paying a rent. When you went round, they said that room was locked by the landlord and the landlord didn't stay there. Inferences can be used and hearsay evidence can be used, and they may be sufficient, as Vandra said. And often it's the evidence of people who aren't there that's actually more compelling. Again, going back to the Riverside case, why did she have no evidence from her adult children who apparently stayed with her from time to time? Why did she have no evidence from her neighbours if she had been there for 26 years as she had claimed? Why did she have no evidence of the people we found at the property when we visited? That is highly significant, and the court may well take that against the individual. So looking at the next slide and appreciating the time, and no doubt Helen will be sending me something shortly, it's worth making the point that the Part 18 request for information is really what I want to focus on. What I would say about the Data Protection Act, however, is that Katrina's right, that it should not be seen as a problem, but what it is, it's basically something that allows somebody to provide information. They may choose not to, and I saw from one of the Q&A comments, somebody said that, I think it was the NHS aren't very good at providing information. But it is something that shouldn't be a bar on them providing information if they are prepared to do so. Equally, it's worth saying that you can make an application for third-party disclosure under 31.17 of the CPR. It's got to be relevant. Obviously, you can't go for a fishing expedition, but if it's going to be relevant and likely to support or adversely affect one party's case, that's required. And if it's necessary to dispose fairly with a claim, then it may be that an order will be made against that third party to provide information. So that's 31.17. Neighbours, very rarely determinative, but very useful. We can move on because, as I say, I think the rest of that is fairly self-explanatory. Yes, this is a very pretty slide, which I'm not going to go through in any detail, but all it shows is that there are exceptions to the, effectively, if I can put it this way, the protection of data. If you are seeking to prevent unlawful acts, if you're seeking to prevent fraud, if you are involved in litigation. These are exceptions to the Data Protection Act, which means that you shouldn't have anyone saying we cannot provide. You may have somebody who says we're not prepared to provide, which is when you look at the 31.17, but you shouldn't have anyone saying we cannot in these type of cases. We can go on to the next one. The Prevention of Social Housing Fraud Act regulations that you saw reference to earlier simply allow a local authority in a housing fraud investigation case, which the next slide will set out what that means, but effectively is subletting any fraud act offence, etc., to get information from people such as credit companies, banks, and utility bodies, not the telecommunications, but utility bodies. And that's why you should easily have, for example, bank statements. It should always be the case you have bank statements to show money going in from subletting, for example. Not always possible, not always available, but it's worth having. And that is something that the local authority have the power to do. So it's important if you're a housing association to work with your local authority. And we can skip a couple of slides, Helen, because that's just the list of offences which you'll get when you get it. Helen's dealt with, sorry, you haven't dealt with it, but Katrina dealt with the question of DAFIN, electoral roll, credit records, etc., and utility usage. Very useful, incidentally, for unlawful profit orders and only or principal home cases. Part 18 request for information. Many people just do a bare defence. They just deny. So you've done all the pleading, which talks about we visited the property and Mr. X and Ms. Y answered the door and said they were paying rent, and the defendant just says denied. You say, well, I need to ask you some questions. Do you know these people? Why were they at your property? Why would they say that they were paying, etc., etc.? And you can ask that fairly informally initially, but ultimately, if they refuse to answer, you can get a court order requiring them to answer. And if they fail to do so or fail to do so properly, you can get an order debarring them from defending the claim and even striking out the defence. So it is an important requirement, and it is to enable you to know what their case is and to avoid bare defences, where they just simply say, no, I'm not doing anything wrong. And you can ask any questions you want. I'm going to leave this page for you to read, given the time we have, but it really is very important to remember that in these kind of cases, you are front-loading the claim, a bit like antisocial behaviour cases. You are front-loading the case so that when the claim is issued, you have probably got a witness statement as well. Your pleadings are probably more detailed than you would have normally for certainly more than a rent claim. And it's really important that that is put very clearly. Just very quickly, because I've only got probably 1 minute left. Allocation fraud is fairly straightforward. Allocation fraud is obviously somebody who has lied or has been reckless as to the truth in getting their property. It is a discretionary ground for possession, and so it should be remembered that it is something that, although it's a criminal offence, could lead to them still being able to stay at the property. What I would say is use that Turner quote. If you can prove that somebody has misled, so for example, they didn't tell you on the application form that they had an interest in another property, and if they had have done, they wouldn't have got that property that was let to them. It's a classic ground 5 or ground 17 case. And in terms of discretion, if you go on a few slides, Helen, you'll see some cases I've set out which really kind of make the point that this is different than other cases. In particular, you may wish to look at Rushcliffe and Watson as a classic case where it's about public policy. The courts, although it's discretionary, are likely to say, I don't care if you're likely to be made homeless. That's obvious from a possession claim and a possession order, but it shouldn't be allowed to keep these matters running. So unless you can come up with something very compelling, and of course, some of you will remember, if you're a bit obsessed like me with the public sector equality duty, the recent case of Luton Community Housing Trust and Dodana, which was actually a ground 17 case, which has gone back to the county court to determine. But Rushcliffe and Watson is the most crucial case there. And then just to finish very quickly, makes the point that a lot of these activities are criminal offences. My own view, and I know when I did a talk at Capsticks, which was probably now a couple of years ago, maybe 3 years ago, with Helen, I know somebody in the audience said, we always prosecute. We prosecute every case. I'm not a great fan of that, to be honest with you. It seems to me PR-wise, it's a good PR, as we've seen with Riverside, to say, look, we've got the property back. We've not only got the property back, we've got a healthy unlawful profit order. That's just as good as saying we were able to convict and somebody got a suspended sentence and a £100 cost order. So what? Now, that's not to say you prosecute, but I'm not sure it's the be-all and end-all. I prefer to concentrate on the civil side of things. And of course, you can do both. But it seems to me it's worth knowing that Parliament has said a lot of what we're talking about are also criminal offences, which is how seriously they should be taken. The next one, just very quickly, there are, of course, in the criminal courts, the power to do compensation orders, particularly for local authorities who have let properties to people who weren't entitled to them and in the meantime have had to put people into temporary accommodation who should have got those properties. And of course, there are confiscation orders to make sure that people don't profit from their crimes. And of course, the criminal courts can also do unlawful profit orders like the county courts can as well. And lastly, on the civil side, you have got civil recovery. I have to say, for housing associations and from housing associations, we're really talking about obviously cost orders and unlawful profit orders. The tort of deceit may be appropriate, but you then have to think, what is your loss? Because if you're accepting nominations from a local authority and somebody, for example, is in your property who shouldn't be, it's not you that are putting people in temporary accommodation, it's the local authority, and therefore the loss is them. So normally you're focusing on the unlawful profit order to make sure somebody hasn't profited from their activity of subletting, and obviously a costs order for your costs of the possession action. And that's just a shameless plug, so don't worry about that. So I'm going to hopefully left enough time for some questions and answers if people have them. Apologies for the very quick run through. As always, overly ambitious and not achieving what I wanted to, but it's now time, I think, isn't it, Helen, for some Q&A?
Thank you. Thank you so much, Andy. That was absolutely great. And I know we haven't given you much time because there is so much to talk about when it comes to fraud. So I hope that that was enough. And of course, there's been a few questions about the slides and the presentation. Don't worry, you're going to get copies of all of this so that you can digest it at your own leisure. So don't worry about that. You're going to get it all, because it's very hard for us who love these kind of things so much to be able to curtail ourselves for a simple 20 minutes. So we've had lots of questions. So we're just going to spend as much time as we can doing those. I did have one question that I briefly answered. I think it's from my old colleague, Sarah, in relation to what notices to serve when it comes to subletting. Now, my view has always been to serve a notice to quit and a notice of seeking possession at the same time, dealing without prejudice to each other. That covers you then, because in terms of section 15A and losing security of 10 years as a result of subletting, you're using the NTQ. You're also using the NTQ for not using as your only principal home. So there's two arguments there on your NTQ. Then if for some reason that's either defective or that argument falls apart, you've then got your notice of seeking possession to fall back on your breach of tenancy and any other grounds that apply. And that was proven in the case that Andy mentioned, that was my one, the Poplar Harker and Begum one, because there was a lock on one of the doors. So the judge actually found that because the fraudsters had been clever enough to put a lock on one of the doors, they hadn't sublet the whole. So in fact, the subletting part of the claim wasn't satisfied. So had we not have served the notice of seeking possession as well and relied on grounds 12 and other grounds, our claim would have failed. So it is really important to serve both notices. Just do them without prejudice to each other, and then you're covered on all fronts.
One of the other things I'd say in respect of that, and thank you, Helen, is that, you know, clearly it's important and a real objective to get the property back. What I nearly always do is when I serve a NOSBAND, a notice to quit, my covering letter says, if you give the property back, that'll be the end of it. There will be no possession proceedings, but I reserve the right to issue a claim for the unlawful profits, because otherwise they just walk away with the lot.
Yeah, absolutely. Okay, let's have a look at the questions. So the one that has gone to the top starts off with, this is very, very good. We like that. Could the relevant forms wording mentioned by Katrina be circulated too, please? So Katrina, you'll be able to deal with that one. Is that okay?
Yep.
Marvellous. In relation to speaking to the subletters, I do advise them that they will have to leave, but make them aware of the Protection from Eviction Act and reassure them that they will not be out on their ear and that there is a legal process and these things take time, but it's advisable to start looking for somewhere else. I think that's good advice. I mean, you have to be...
It is, although it's worth remembering that that's absolutely right from Garen, but they have no rights vis-a-vis the landlord. Their rights are vis-a-vis the tenant. And therefore, for example, they will have a right for a breach of covenant to quiet enjoyment claim against them in damages for what it's worth. But equally, in terms of when they have to leave, of course, they can't leave except by a court order because they have a tenancy vis-a-vis the tenant. You know, if we get there first as a landlord, then of course our possession order will affect everyone, subtenants and tenants. But if not, my experience has been is that tenants often rather belatedly try and get back in and just chuck their subtenants out, which is unlawful and gives that subtenant a right to a damages claim against the tenant.
Absolutely, and don't forget how, you know, you're actually probably going to need these subtenants as part of your evidence. So it's really good to be, you know, kind, as Katrina said in her presentation, be kind to them because they're actually very, very useful to you in your evidence gathering mission.
But it's worth, Helen, also absolutely right, but also if you can, get in some form of statement from them, because even if they're not very interested by the time it comes to trial 6 months later, at least you've got something which is hearsay evidence, but it's contemporaneous, and there is a reason why it is hearsay, and therefore would be very important, because sometimes you either get them not doing anything at all because they've moved on, as I say, 6 months later, or else the tenants got to them and then they're saying, well, I actually wasn't paying rent. And you can say, well, wait a minute, you told us when we visited, without any pressure from us, you were paying rent. Get it in writing and get something in writing and get them to sign it. I don't really care if it's a formal witness statement, just something which you can say was a contemporary note of the position at the time you visited.
Absolutely, it's so valuable to have those things before anyone's had a chance to think about what they want their story to be. Yeah, totally agree. Haya, what approach would it be best when landlords, local authorities are not sharing information requested? So Andy, you dealt with this in your talk, didn't you, Andy?
Yeah, I would also say, I mean, obviously on the softly approach, one of the great things are data sharing agreements. And if anyone, I would always recommend them having a look at the Information Commissioner's Office's website, because they actually have the updated code of practice on that. And it's always a good idea, if you're a housing association, for example, to have a data sharing agreement with your local authority for future cases as well as present cases. So if you haven't got that at the moment, it's worth looking into that. And as I say, as a start, apart from looking at everyone else's policy, of course, it's worth having a look at the Information Commissioner Office's code of guidance on data sharing, because that may assist. Other than that, of course, what can you do? You can, can't do a great deal if they're not prepared to assist, unless, of course, they're the ones with the information, in which case you can have the 31.17 application.
One of the questions is, how can we get councils to help? Local authorities say they will not investigate non-council tenancies where there's suspected subletting. So in terms of joint working, there are some local authorities who have, one of the seminars that we did pre-COVID, we had one of the external speakers from Thurrock Council, and they have central funding from central government to be able to give their services to people outside their borough. So if you're a housing association and you want to jointly work with someone who's got a fraud expertise at a local authority and get them to work with you, you can engage these local authorities, that even though they're not your local authority. So there are some that you can do that with.
And in the Riverside case, Helen, that's what actually happened. I think the service was from Oxford, even though the property wasn't. Was obviously a London. Well, it wasn't obviously a London property, but it was a London property. So yes, absolutely. I mean, a local authority is the one who's got the powers, for example, of prosecution, the powers of investigation. So yeah, it's possible to, if you've got a very proactive local authority, they may be perfectly prepared to assist well outside their area.
There are a number of Helen says, local authorities who do sell their services, and I think that's marvellous. Other local authorities will assist. I mean,
Michael's also indicated that, in fact, on his.
Okay. They'll also assist if you say, well, ABC Housing could say to the local authority, well, look, if you get this property back for us, then you can have the nomination. And we'll take someone from your homeless persons list. So joint working is so important with tenancy fraud, and on the whole, people are really, really keen to assist.
And we're getting some good feedback. People saying they've used Thurrock and used Oxford, and they've had good results. So that's good to hear.
I mean, I think what's important to remember is that we're primarily talking about the civil route. So we're primarily talking about balance of probabilities. And because in many instances, you've got enough evidence to throw the burden onto the tenant to explain why there are these discrepancies, it's only on balance of probabilities you need to get home. Mm-hmm. And therefore, it's very important, because if I'm having to prove that I'm living where I say I'm living, and I'm not subletting, it should be quite easy, shouldn't it? I should be able to, even if I don't really know the names of, which I don't, my neighbours, they will have seen me over the last 10 years, and they'll be able to say, yeah, of course he lived there. Don't have a clue what it's called, but he lived there. Whereas if you don't, you have to ask yourself, well, why haven't you? Because it should be quite easy to show that. Whereas if I've been subletting the property for the last 10 years, then of course they won't know who I am, because I'm not the one who's been there. There's been a family, who are anyone other than me. And therefore, that is highly significant. And I think, as I say, I think people underuse, they focus on what evidence they have. They don't focus on what evidence the tenant doesn't have and doesn't call. And if you're being an honest person, you would call fairly obvious evidence, as I indicated with the Riverside case.
Excellent. Right, well, I think we've covered all the questions there. We've even done a bit of matchmaking. We've got local authorities being able to get in contact with housing associations. So that's an excellent result for us there. Right, we have reached...
There's one from Pamela at the end. The one from Pamela at the end?
We have a direct waiting list. How can you suggest that we check if the applicant is already claiming homelessness or on the housing register with a local authority?
Well, I mean, I think two things really. I mean, one, obviously, if that is a problem, then obviously you want to make it clear from your own waiting lists that you're required to inform you, just in case you want to then in future, if need be, use a ground 17 case if you're a housing association. And obviously it's a question of, contacting the local authority. I mean, my experience, and I appreciate I'm not really at the front line of these things where the investigators and the solicitors are, but my experience has been that they're often very willing to just say, no, they haven't been on the register, or they are on the register. It may take a bit of time sometimes, etc., but there's certainly no data protection issue. And it should be fairly straightforward for that to happen in principle. I mean, to be honest with you, any practical problems, it's the same practical problems anyone would have in any area of law about trying to get information from people. As I say, I think it's that twofold approach. Make it clear to people what they're required to tell you, and then try and get the information yourself, or even ask the individual, look, we want you to get the information to confirm that you're not on the list or whatever.
Yeah, and it's often with getting the right contacts and building relationships with external people. I've never had any issue with all my time working in housing associations, getting people, local authorities to assist me. They usually mention the word fraud and they're really happy. But again, the Tenancy Fraud Forum, if you wanted to link in with that, will enable you to forge those professional relationships with people and find out who does what in various organisations if you're not sure.
And can I just say with Jill's question about her client in Iraq, not her client, sorry, her tenant in Iraq, and saying they're there for medical reasons, blah, blah, blah. Well, of course, if that's genuine, they're still living there as their only or principal home in the tenanted property, and that's fine. I always say, serve the notice to quit as early as possible. You can wait with the notice seeking possession. The notice seeking possession is just a warning. If it's a periodic tenancy, serve your notice to quit as early as possible. If it transpires the tenant's telling the truth and they were living at the property at all times, they just couldn't get back to it because of ill health, because of family problems abroad, fair enough. You just don't do anything with the notice to quit. It has no effect. But serve it as early as possible. And if it's shown that this idea that it's purely medical reasons, which has meant that they've been there for 2 months, if not longer, then obviously you can use it and say, well, no, we don't think you're there as your only principal home. The point is, of course, with only your principal home, it's an objective intention to return, not a subjective. So when you look at all the facts, if you don't have that medical evidence, why are they away for 2 months? And more importantly, of course, it's even more suspicious if there is a suspicion that somebody else is living in the property in the meantime, because then it may not be an only or principal home case. It's actually a subletting case. Yeah. And therefore, that may be a good indicator that, in fact, it's more than just the concern that you had initially about them not being back in the country.
Okay, well, we had loads of questions. That's really, really great. I hope we've answered as many of them as we can. Unfortunately, we are over, we're a couple of minutes over time, so apologies for running over, but I hope everything was really useful. And as I say again, we will forward the link to the webinar so you can rewatch the content, also the slides. And Katrina has got a long shopping list of things that she needs to do for you to send you various wording and so on. But I hope you found it really, really useful. As I say, what we were trying to do was attack it from both sides so that you could see the practical issues and have some really useful tips as to how to practically tackle fraud, and then also the legal side so that you know why we're having to do what we're having to do and the reasons behind all of that, so you can see how it all fits in and plays together. Thank you so much for joining us today, and we will hope to see you at the next one. Thank you ever so much.